SRIRAM's IAS, serving the nation since 1985. Ab offline ho ya online, we are the lifeline.
Hello students, welcome to SRIRAM's IAS and you are welcome to this 6th class of the series of Polity Current Affairs, which will be very helpful for your upcoming prelims examination of 2025. We have came up with a new very important topic which is going to help you to dive deep in your current affair preparations. Let's see what the topic is all about. I am Mayank Bharadwaj and I will be presenting this class. So this is again Indian Express news, and it was there in other newspapers as well. It was widely covered because it pertains to a very important aspect of sub-categorization of castes, of categories in India. Sub-categorization has not been done in SCs and STs, although it has been done after the Indra Shawnee case in 1992 in OBCs, but it has not been extended to scheduled castes. And Supreme Court, in one of its verdict in the case between the state of Punjab and Davinder Singh, has pronounced that in the final judgment, the Supreme Court said that sub-classification or sub-categorization is allowed. It is constitutional, and if it is not allowed, it defeats the purpose of reservation. That simply means the states, although cannot exclude any category of caste from the list of the castes of the scheduled caste, but within that list it can subcategorize. That simply means whatever amount of reservation which is given to the scheduled castes in a particular list of a particular state, the state can subcategorize those, subclassify those categories and actually give particular reservations to a particular subclass or a subcategory. If it is becoming a complex issue for you, we are going to understand it in the coming slide. So this was the Supreme Court's verdict on subclassification of SCs and STs. Let's go forward. So the introduction thing is that the Supreme Court upheld states' power to subclassify reserved categories based on backwardness. This is very important, and the power of the state has been upheld till now under Article 341. It is the President who has the power to include a category within the list of scheduled castes, but this power of subcategorization or subclassification has been given to states, although the power of President is intact. We are going to see this in the next slide. States cannot modify the scheduled caste list. They cannot modify the scheduled caste list. Simply, they cannot add anything, they cannot reduce anything, they cannot diminish the list, extract anything. Nothing can be done by state. But under Article 341, all these things are done by the President, but they can subclassify within the list. They can subclassify. We are going to come to next slides and is going to understand because it's a bit of a complex issue for many people. So let us go to the basics and understand what is this subclassification, subcategorization is all about. Let us first understand the classes. If you see, India is broadly divided into classes, divided into categories. You must be filling up your forms for different examination, claiming reservations, putting up forms or some sort of certificates to prove your category, to get the benefits of reservation. Everything is happening around us. So we need to understand what this basic thing is all about. So we have categories such as we have general categories, also called as the unreserved categories. Then we have other backward classes, OBCs. The socially and educationally backward classes mostly come under the category of OBCs. Scheduled castes and scheduled tribe, and a new category has also been made, economically weaker sections. Now Article 15 and Article 16 under Clause 4, under Clause 5, they give several special provisions to SCs, to STs, to OBCs. Some special provisions can be made by state for these categories, and there is where the reservation comes up. For jobs, under Article 16, in educational institutions or for jobs, several promotion only for SCs and STs, special provisions can be made by the state. So this is the very basic slide which you have to understand, that there are categories in India. Now we are going to go and understand something further. Now Article 341, it designates president to make the list. So every state, let's say Andhra Pradesh, Punjab, Haryana, UP, MP, all of them have their different list of scheduled castes. Who prepares that list? The list is prepared by President of India. This is the power given to President of India under Article 341, clause number 1. And we are talking about scheduled castes. We are not talking about scheduled tribes. For scheduled tribes, the article is 342. And for OBCs, the article is 340. We are talking about scheduled castes because the judgment pertains especially to scheduled castes. 341 clause number 1. President is empowered to make lists of scheduled castes, different castes, and their list is prepared. Caste number 1, caste number 2, 3, 4, 5. There are a long list of so many castes. Andhra Pradesh will have one list, Punjab will have one list, Haryana, Uttar Pradesh, Madhya Pradesh, everybody will have their own lists according to the people and the caste present in that particular state. Okay. Now, clause 2 of the same article, it empowers the parliament to make changes in that list. It empowers the parliament. It gives the sole authority to the parliament to modify the scheduled caste list. So in both these articles, both these clauses, you do not see the authority of state. The state government is nowhere present. State government is absent. But the Supreme Court has given the power, in the recent judgment, has extended power to the state government to sub-classify these castes. We are going to see how. Consultation with governor is required. For example, if president is making a list for Andhra Pradesh, so the governor of Andhra Pradesh needs to be consulted by the president. Okay. Sub-categorization. Now, we have already seen what is categorization. Categories we have. General category, OBC, SC, ST, EWS. But what is sub-categorization here? That simply means it is the categorization within the classes. For example, if there are scheduled castes, okay, there will be so many castes within it. Now, scheduled caste is seen as a homogeneous class, the whole homogeneous one section, and the reservation of 15% is given to this particular section. Okay. Now, what if we put 4 castes under this category, 4 castes under this category, and 4 castes under this category? Let us name it A, B, and C. And this 15% reservation, which was given to the homogeneous group of SCs, to all of them, let's consider that C is the most backward among the scheduled castes, B is the intermediary, and A is the most forward within the scheduled caste. So out of this 15%, if 7% is given to category number C, okay, 5% is given to category number B, and remaining 3% reservation is given to category number A. Now this will be called as sub-categorization. That you have divided this 15% reservation given to the list of scheduled caste among the subcategories, and the basis of that subcategorization is the backwardness. backed by the empirical data. You should have some data which is very empirical. It should not be politicized just because to make your vote bank you come up and start making and start giving reservations to the community which is giving you more votes. That must not be done. So what needs to be done here is that backwardness must be seen based on the empirical data, and the category which is the most backward needs to be given more reservation. They needs to be uplifted even more. This is the basic idea of reservation. And the Supreme Court has said that if sub-categorization is not there, then that basic fundamental idea is defeated. Okay, so let's see in the next slide. So what I was referring to, for example, take Bihar. So Bihar has a list of scheduled castes. Under that list, there are so many castes which are there. Pasi, Musahar, Dom, Chamar, Mochi, etc. So many of them. And all of them comes under the broader category of scheduled castes. So many of them would be very, very backward. Not all of them would be backward, but many of them would be very backward. So, okay. Similarly, in Punjab, in the present case, Punjab was the state. Balmikis are there, Majhabi Sikhs are there, Ramdasiya Sikh are there. All these belongs to scheduled castes. But when you are giving reservation, okay, when you are giving reservation, you are going to put the most backward classes in one category and going to give more reservation to that category. That is the main purpose of giving reservation. The people who are the most backward needs the most support. The people who are most backward needs to be uplifted even more. They need more recognition. They need more participation in government making. They need more participation in educational institutions. They need more participation in government jobs. That is the whole sole purpose of reservations. That is the reason why such a thing was done with OBCs after the Indira Shawnee case of 1992. But such a thing was not extended to scheduled castes and scheduled tribes. Now, Supreme Court judgment has opened up a, I would say, Pandora box, but at the same time an opportunity to give reservations and more reservation, more participation, an opportunity to participate in education, an opportunity to participate in government jobs to the most backward of classes. Earlier what used to happen, let me tell you, that all the 15% of the reservation would be taken by the most forward of the scheduled castes. They would be there doing their jobs which they have been doing from centuries, and they were not getting any benefit. They were not getting any benefit of the reservation policy of the government when the reservation was homogeneous. That was one of the argument of the people who have approached the Supreme Court on this matter. They said that this homogeneous nature of reservation in a way is against the very purpose of reservation. Okay, I am repeating this thing again and again so that you can understand what this whole issue is all about. When you make categories based on backwardness, you can always see who needs more help, who needs more reservation. The most backward needs the most. Okay, and accordingly you can give the reservation to such category or to such subcategory. Okay. So what are the developments which has happened? Let us see the developments. So sub-classification was permitted in Indira Shawnee case. This was in 1992. What all was permitted? It limited only to backward classes. Okay, it did not extend to the scheduled caste and scheduled tribe. It was not applicable to scheduled castes but was limited to backward classes. Then 50% ceiling on reservation. This is one very important issue that you see. Now what happens in India, usually OBCs, they get around 27% of reservation, SCs 15% of reservation, and STs in the central list I'm telling somewhere around 7.5% of reservation. This reservation, if you total this up, will not be more than 50%, it will be somewhere around 49.5. Okay, so this ceiling of 50% needs to be there when you are giving reservation to scheduled castes and scheduled tribes and OBC. Okay, the reservation must not go above 50%. This was an important provision added by the Indira Shawni case in 1992 by the Supreme Court judgment. The another important provision was the creamy layer concept. Now there is a difference between what is creamy layer and what is sub-categorization. In sub-categorization, you are trying to find out the most backward category. Sub-categorization, you are trying to find out the most backward category, and when you find out these most backward categories, the most backward castes, you give them reservations, you give them the opportunity to grow. In the creamy layer concept, you are trying to do the opposite. You are trying to find the most forward castes. Among the list of, let's say there's a state list and there are 50 castes total. Let's say Andhra Pradesh or some other state has a list of scheduled castes. There are around 50 castes which are listed in that. Among them, you can say there are 5 castes which are highly developed. Remaining 35 of them are normally developed. Okay, and then how much is remaining? The last 10 are least developed. So you can say that the most support, the most reservation is needed for this 10 castes. So this is what is sub-categorization. And creamy layer is you are trying to pick up these 5 and stop giving them the reservations, stop giving them the benefits. Why? Because they are above the creamy layer. Creamy layer simply means that the historical benchmarks which were made, the historical abuses which these castes and categories have faced, in the present times they do not face such abuses, they do not face such backwardness, and the social and the economic condition of these classes are such that their castes does not in a way affects their living, their way of life, and their social connect and economic connect. Okay, this is a very important concept. Now the argument which comes is there are other backward classes people who can be categorized as people above the creamy layer, and their caste has no impact on their social and economic standing. But such is not the case with scheduled castes. Even if a scheduled caste person or a scheduled caste family or a particular caste has developed tremendously in today's India, but just because of their belongingness to that particular caste, they face social and economic exclusion. And that is the reason why creamy layer concept cannot be included in scheduled class. This is the one of the argument which were given, which has again been given in Chennaiya case, then again given in the present case. So this creamy layer concept is a very tricky concept. So Supreme Court has in a way accepted this particular creamy layer concept, and it has also said that it can be individualistic rather than applying it totally onto a caste. So this is the case of 2004. It's a very important case because it rejected the challenge to the provision. See, Andhra Pradesh has came up with one act, Andhra Pradesh Scheduled Caste Rationalization of Reservation Act of 2000, and this act was challenged in 2004 in the court, in the High Court of Andhra Pradesh. So through this act, the government of Andhra Pradesh has provided what? they have classified within their list, they have classified the whole list of different castes into 4 categories. They have classified them into group number A, group number B, group number C, and group number D. Okay, and they have given 1% reservation for group A, 7% for group B, 6% for group C, and 1% for group D. This is again an example of subclassification, subcategorization. This was rejected in this Chennaiya case of 2004. This became the basis of the present, the opposite party in the present case, the Balwinder Singh and others. They have relied on this case, heavily relied on this case to tell to the Supreme Court that already this idea has been rejected by court earlier. But the state of Punjab wanted to have the power of subcategorization, and now it has been allowed by Supreme Court judgment. So what was the judicial pronouncement in the present case? Okay, let's just go through it one by one. Supreme Court held that E.V. Chennaiya, which had declared sub-classification, we've already seen the sub-classification was done into 4 categories of A, B, C, D, giving different number of percentages of reservation to different castes. Within the scheduled caste, impermissible does not lay a good law. That simply means Supreme Court has overturned this judgment of 2004 and it has allowed the states to subcategorize the castes further. The court directed that any further or any future subclassification of scheduled castes by the state government must be based on, they need to have empirical data. They need to have empirical data, and the process has to be fair and reasonable. Arbitrariness, politicization of the process, these things are not going to work. The process has to be based on some reason, some logic, okay, and at the same time the data which you are using to give reservations or to subcategorize the castes, that has to be empirical, logical, logic based scientific data. Okay, it should not be some data brought from some manuscript of ancient India. It needs to be empirical. Recognition of subclassification. Now these are different facets of the same judgment, judicial pronouncement, which has been made in the present case. What all Supreme Court has said about the whole issue. Recognition of subclassification as constitutional. This was not constitutional. We have already seen that under Article 341, clause number 1, President have the power to form the list with the consultation of the governor, and 341 clause number 2, the Parliament have the power to modify the list. It can act or remove any caste from the list, and the state government did not have any power in this regard. But the power to subclassify that particular list which is made by the President has been extended to state governments, and it has been made constitutional power. That's a very important judgment, very important for your examination. The court held that subclassification of SCs for targeted benefit is permissible under Article 16. It gives several important facilities under this Article 16.4. Special provisions can be made for SCs. Okay, and after subcategorization, targeted benefits will be permissible to these subcategories under Article 16.4. Relates with job in the educational, admission into the educational institutions and job into the government. Government being a model employer needs to follow the fundamental rights. It stated that threatening all SCs as a single homogeneous group. Now this is an important, very, very important point. Treating SCs as a single homogeneous group would defeat the purpose of reservation. Because what is the meaning? If this is the whole SC class community and a portion of it takes all the benefits of reservation, leaving everybody at the periphery, what is the meaning of reservation if the reservation does not trickle down to all the people in an equitable manner? That is the purpose of reservation. Can be solved by sub-categorization. That is the view of the court. The court ruled that the creamy layer principle is applicable. This is very important. Is applicable to scheduled castes and scheduled tribes, though the criteria for exclusion, who needs to be excluded from the list of reservation, that simply means who can cross the creamy layer. That exclusion thing may differ from that applicable to OBCs. So whatever criteria to select people who are above creamy layer for OBCs, that criteria may differ for SCs and STs. It's a very simple statement. Now, this was our last slide. Yes. And we have studied a very important judgment where sub-categorization or sub-classification of the castes are allowed by Supreme Court, giving constitutional power to states to do so. This power was not there because the sub-categorization of SCs and STs was not allowed. Why? Because in Indira Shawni case, the sub-classification and the creamy layer concept was allowed to OBCs but was not extended to scheduled castes and scheduled tribe. But in order to fulfill the purpose of reservation, it became very important in the view of the Supreme Court to allow the states to sub-classify, sub-categorize the different categories, the different castes, in order to give benefit to the most backward sections, most backward citizens. This is a very important piece of information for your prelims examination. Thank you very much for joining me, and I hope we'll meet in the next class with a very important topic which will help you to clarify and clear and crack your 2025 prelims examination. Thank you very much and have a nice day.
SRIRAM's IS, serving the nation since 1985. Ab offline, hoya online, we are the lifeline.